So it's Thursday the 16th of March, and the High Court judge, I think Mr Justice Brian O'Moore, has ordered that Enoch Burke must pay the fine of €23,800 by next week over what the judge has described as egregious disobedience of court orders. He's gone on to say that the school may apply to enforce payment of fines by seeking orders over Enoch Burke's assets. So, according to the judge, he's in egregious disobedience of a court order, and Mr Justice Brian O'Moore has said the school may apply to enforce payment of the fines by means such as seeking orders over Enoch Burke's assets. He said the €23,800 figure was based on fines of €700 daily imposed from January 27th to March the 1st. But warned that fines of €700 daily have and will continue to accrue until he purges his contempt of court orders not to attend at Wilson's Hospital School. In considering whether the daily fine of €700 should be increased, the judge said he had concluded that there are two possible reasons for Mr Burke's continuing contempt of the orders. The first was that the fines are too low at €700 a day, and the second is that Mr Burke does not really believe they will ever be enforced. He had decided that the correct approach, the judge has decided, was to crystallise the sums due as of the 1st of March and to make a court order requiring those to be paid by March the 23rd perfected, meaning the school could then take steps to enforce payment. And just to clarify that, the school could take steps to enforce payment in a normal debt collection scenario or proceeding. The clear and obvious steps to enforce payment, including sequestration of Mr Burke's assets for the purpose of enabling collection of the fines, he said. The school is at large to consider what steps it wishes to take to enforce the fines. He was giving his ruling on whether Mr Burke is in continuing contempt of the orders not to attend at the school. The orders were made in August and September after the school placed Mr Burke on paid administrative leave pending a disciplinary process. That process arose from a publicly voiced opposition at a school chapel event in June 2022, and it was to do with a request from the school principal at the time, Niamh McShane, that teachers address a transitioning student by their preferred name and using the pronouns they, them. So he was jailed in September for 100 days. In his ruling on Thursday, Mr Justice O'Moore ruled Mr Burke is in continuing contempt. He said the evidence was that Enoch Burke is continuing and deliberate breach of the orders not to attend at the school, and his claim that he was not causing disruption was not consistent, to put it mildly, with the school's evidence. The evidence of the school was that Mr Burke had attended the school every day since January 26th, when the decision to impose fines was made, except at weekends when the school was not open and when he was in the courts. Mr Burke did not dispute that attendance and had said that since his release from prison on December the 21st last, he had continued to report for work. Mr Burke had argued that the contempt orders were unlawful, but it is not his role to decide whether court orders are lawful, the judge said. He also made orders awarding the school its costs of 2 pre-trial applications in the proceedings against Mr Burke, so that's more money to be paid. He rejected arguments that requiring Mr Burke to pay the cost of his unsuccessful application for a stay on the main hearing of the proceedings pending the outcome of his appeal over the injunctions penalised him for his religious beliefs. He said Mr Burke had criticised the school's conduct of the proceedings and had described his own conduct in terms that he had at all times conducted himself in a proper manner in these proceedings. The judge said that this self-praise beggars belief. There is much to be said about Mr Burke's behaviour, but it may be sufficient to observe that a person who has refused, on utterly spurious grounds, to comply with a court order for some 6 months has not behaved properly. The judge also noted the baseless traducing in some submissions by Mr Burke of other judges, as well as his conduct in disrupting not one but 2 sittings of the Chancery list in February. He rejected arguments by Mr Burke that some admitted errors in evidence provided by the School Board of Management Chairman John Rogers justified the court refusing to award the school its costs of the 2 motions at issue. Mr. Rogers' evidence never featured in those motions, he noted. Any infirmity in the evidence of Mr. Rogers will be put to him at the main trial in the event that Mr. Rogers gives evidence, he added. The judge noted Mr. Burke had yesterday emailed an unusual letter to the court registrar in which he expressed concern the fines were in place for breach of an order based on the use of false statements. The judge said he had dealt with that issue in a ruling on February the 4th, which addressed the school's application to correct certain statements in earlier affidavits. He had said because the erroneous affidavits were not put before him, the errors be brought to the attention of the relevant judges, and both the school and Mr. Burke were free to do that. The judge said, as far as he was aware, Mr. Burke has not done so. It was not for him to decide whether any of his colleagues were materially influenced by the false evidence, and that is why it was neither necessary nor appropriate for him to have the question of the admitted errors in the school's affidavits listed before him. The main hearing of the proceedings between Enoch Burke and the school is set to open at the High Court on March the 28th and is set to run for 4 days. Mr. Burke is separately appealing against a notice served on January the 20th from the School Board of Management for his dismissal from the school. That reporting is from Mary Carolan, the legal affairs correspondent of the Irish Times. So this case is going to go to the full hearing on March the 28th, set for 4 days in the High Court, but the order today is that Mr. Burke must pay €23,800 fine by next week over his egregious disobedience of court orders, and in addition he has had the costs of 2 motions, pre-trial motions, awarded against him and in favour of the school, and the school is open to sequestration of Mr. Burke's assets or any other method that they wish to pursue in order to enforce the fines. Hope you find this video useful. If you do, I'd appreciate if you gave it the thumbs up down below. Thanks a lot.